At one time or another, they all come to the Ron Sedgy Show. So why don't you?
And welcome. It is time for the Legal Lounge. It's time for Richard Nixon Live, broadcasting coast to coast and around the world on CRN Digital Talk Radio. That's crntalk.com. Also, check us out on Facebook, facebook.com/CRN Talk. Scroll to videos and join the conversation there. We are so happy to be joined by Richard Nixon. He's a practicing attorney, a Vietnam-era veteran. He's got a bachelor's in science in physics, a doctorate of law, and he's author of America, An Illusion of Freedom, a fantastic book available on Amazon.com, iTunes, as well as Barnes & Noble. Richard, sir, how you been? How's your Labor Day?
Absolutely great. Had a lot of hot dogs and hamburgers.
There you go. A nice ice-cold beer with that, too?
Absolutely.
That's the American way right there, my friend. We are so happy to be here. We are here every Tuesday at 4 p.m. Pacific time, at 7 p.m. Eastern time. Past episodes are available via YouTube, and it was also on our CRN podcasting app. What are we going to get into today, Richard?
Well, I thought we'd get into a little bit of the First Amendment, at least the freedom of speech portion. I know that President Trump made it a bit current by mentioning New York Times versus Sullivan several times, so I think it's apropos to maybe review how we got to where we are in the First Amendment.
Yeah, there's three seminal cases that we're going to get into over the course of this hour. We're going to go in chronological order. Like you said, New York Times versus Sullivan. We talked off the air as a broadcasting background and a communications major. New York Times versus Sullivan was a very important case we studied. After that, we're going to talk about a Cohen versus California, and we're going to try very hard not to use the expletive in that case.
Absolutely.
So I have the 7-second delay on standby. And after that, we're going to talk about Texas versus Johnson, which is a case, a very, very seminal case regarding desecration of the American flag, and that's a very, very important case. But I would be remiss if I did not mention very, very happy birthday to one Miss Debbie Barea, our social media director. She runs things in the front. She's an absolute, she keeps the trains running on time. She turned a very, very nice 26, and so happy birthday.
Happy birthday, Debbie. And I thought you were about 19.
I guess she was 23, but I remember age 26. That's a very, very fun age. So
yes.
We hope she enjoys that. And once again, Richard Nixon, he's a practicing attorney and an author as well. You can see if you're watching on YouTube right now or on Facebook. Check out his website, www.pres37th.wix.com/America, or just search America, An Illusion of Freedom on Amazon, and his book will pop up. And we always like to mention this, too, that if you knew Richard during his time of service, if you personally knew Richard during his time of service, stateside 63 to 65, or when he was in country in Vietnam as a contractor, give us a call here at the studio, 818-818-6400. That's 818-818-6400, and we'd like to provide you a free book.
Yes, absolutely.
Absolutely. There you go. And we had a good time talking before the show. We always have a great time talking and prepping for the show. And, big news today about Mr. Kavanaugh appearing before the Senate Judiciary Committee for his confirmation of Supreme Court. And a sitting United States senator echoed some of the most salient points that we have talked about on this show.
Absolutely.
It almost makes me feel like he's listening. We might have to actually send him a bill for for providing those points. We're going to play that sound at the very, very end of the show because I think it's very, very important and it really represents what we talked about on this show and Richard's core philosophy on where the judiciary stands in the institutions of power in this country. So we'll be right back, you guys. Richard Nixon live in the Legal Lounge here on CRN Digital Talk Radio, streaming live coast to coast and around the world on crntalk.com. If a question or a comment, leave it in the Facebook, crntalk.com/videos, or give us a call, 818-818-6401. That's 818-818-6401. We'll be right back in 1 minute.
What are you going to do with your old car? You can try selling it, you could junk it, or you could donate it to Heritage for the Blind. Your car will be towed away for free, and your donation is tax deductible. Just call 1-800-785-9618. Heritage for the Blind accepts cars, vans, trucks, and boats. It doesn't matter if your vehicle runs or not. It will be towed away for free, and you'll be supporting those that need help. Heritage for the Blind is a nonprofit organization that helps the visually impaired live fuller lives. Call right now to donate your car, and as a special thank you for calling, you'll receive a free 3-day vacation voucher to many exciting locations. Call Heritage for the Blind right now, 1-800-785-9618. Donating is easy, and your vehicle is towed away for free. Plus, you'll get a free vacation voucher. Call now, 1-800-785-9618. That's 1-800-785-9618.
Welcome back to the Legal Lounge. Richard Nixon live, CRN Digital Talk Radio, crntalk.com. We are talking all things legal, all things constitutional with Mr. Nixon. He's a practicing attorney. He's a recreational conga player. And he's got a fabulous car collection as well. We love talking about that too. But we're talking about the First Amendment today, you guys. Everybody knows from your basic high school civics class what the First Amendment is: freedom of speech, freedom of the press, but maybe not so much.
No, that's right. In fact, if we look at the First Amendment and quote it here briefly, it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press. Today we want to just talk about the freedom of speech portion, but I want to repeat that as of 1791, Congress was absolutely forbidden to pass any law regarding freedom of speech. Now, what does that mean? That means, frankly, that the states could. That is to say, the states were not prohibited from passing laws regarding freedom of speech, freedom of press, etc. And that's what makes these three cases that Mike mentioned earlier interesting, because these are all three state laws or state constitutions that the Supreme Court decided were all unconstitutional.
That's absolutely correct. And let's get started. First off, let's hit the ground running here with New York Times versus Sullivan. And often talked in circles that I frequent, in the broadcasting and communications circles, that New York Times versus Sullivan was a landmark decision that really it establishes the actual malice standard. And can you kind of talk us through what that is?
Yes. In general, almost every state has laws regarding defamation, and defamation really means that you say something false against another person. And normally they're pretty hard to prove in terms of damages, unless you call, let's say, a doctor a butcher. You might call it an attorney a shyster. If that results in either the doctor or the lawyer actually losing business, he can state lost profits. He can sue the person who defamed him, again, assuming that the statements were false. Now, what's different about the New York Times versus Sullivan case is you had an uproar in the South, Alabama, and the plaintiff sued the defendant, New York Times. He was from Alabama, for defaming him. There was a certain advertisement saying certain things were going on with the civil rights movement and that the police or sheriffs were mistreating the people. And as it turns out, some of the particulars of the advertisements were false. Now, a jury awarded the plaintiff in that case $500,000. And it went up to the Supreme Court, and the Supreme Court said, no, wait a minute. Since this is a public official or public figure, we find, and again, now this is where the Supreme Court is writing law, because remember, under Article 1, Congress can't pass a law regarding the First Amendment, freedom of speech. But the Supreme Court took it upon itself to write the law, and it basically said that the constitutional guarantees require a federal rule that prohibits a public official from recovering damages for a defamatory falsehood relating to his official conduct unless he proves that the statement was made with actual malice. That is, that it was false, or that he knew, that he knew it was false or acted with reckless disregard as to whether or not it was false or not. So here we've got the Supreme Court, again, writing law.
Just some brief background on this case for our listeners. It comes from a very ugly part in our history. There was a lot of divisiveness and a lot of strife. This is during the height of the civil rights movement. This is 1964 Alabama. Just so our listeners know. And before this decision, there was nearly $300 billion in libel action from southern states outstanding against news organizations because these southern states and their elected officials were not happy with the way that the northern press was covering the civil rights movement and the South's reaction to the civil rights movement. And this Sullivan out of this case is L.B. Sullivan. He was the Montgomery, Alabama Public Safety Commissioner. Even though he wasn't named in the advertisement by name, Sullivan argued that the inaccurate criticism of actions by the police was defamatory to him as well because it was his duty to supervise the police department. And so even though he wasn't directly named in this advertisement, the inference was that the whiff of the meaning was unmistakable that it was gauged towards him. And because Alabama law denied public officers recovery of punitive damages in a libel action on their official conduct unless a written demand was made, and he made that demand. And subsequently, the New York Times did not retract the article. They only retracted the article later on when the governor became involved, which is very, very interesting. But what's interesting in just my cursory research is that the Alabama State Constitution of 1901, one of the longest constitutions in the
that's
nation.
interesting.
Yeah, it's California, Alabama, longest ones. In Article 1, Section 4 of the Alabama State Constitution, they already had codified freedom of speech in a manner. They said that there shall no law shall ever be passed to curtail or restrain the liberty of speech or the press, and any person may speak, write, or publish his sentiments, but this is what they added, being responsible for the abuses of that liberty. That seems like relatively reasonable language.
Well, it does, except it seems to forget all about what about false statements. Now, again, I applaud the Alabama legislature for saying that you can't stop a person from speaking. That's fine. But that is in addition to the laws regarding defamation. I don't see where that says that they sanctioned false statements about someone. And again, the only reason I bring this up today is to show that this kind of decision is, in my view, erroneous for at least three bases. Number one, we know that Congress was prohibited from passing any laws, so the state passed a law. The state passed a law which the Supreme Court didn't like. So what did the Supreme Court do? They stuck their nose into the state of Alabama's law and found that law unconstitutional, and then wrote what the new law should be. So again, we've got the Supreme Court violating at least two tenets of the Constitution that I know of, and the third one, frankly, is applying the Bill of Rights to the states. That is to say, that's how the Supreme Court was able to micromanage in all three of these cases freedom of speech in these different states, because they applied the Bill of Rights to the states through the 14th Amendment Due Process Clause, which they had no authority to do.
Absolutely. Once again, one of the common themes of the show, of your philosophy and your book, is that the federal government only makes laws regarding the federal government, not the states themselves. And in the Supreme Court decision of Sullivan versus New York Times, that they held that news publications cannot be sued for libel by public officials unless the plaintiffs were able to establish actual malice in the false reporting of the news story. And establishing actual malice is a judgment call, and that makes it the onus on the plaintiff very, very difficult.
Yes, but again, it's limited to public officials and public figures. That is to say, a movie star or a politician who has access to a microphone can easily defend himself if the New York Times, in this case, says something false and slanderous about the person. This is why they elevated the standard of proof. That is, if you do have access to a microphone, you can easily defend yourself, and therefore they've raised the bar for proving defamation.
Well, and what constitutes a public figure is something interesting, and we'll talk about that after the break. And there's the old adage, never pick a fight with someone who buys ink by the barrel, and the New York Times buys it by the truckload. And so I think that the playing field may not be that fair, even if you are a public official. But we're going to talk more about this after the break, you guys. Check us out on Facebook, facebook.com/CRN Talk, or give us a call, 818-818-6401. Back with Richard Nixon right after the break here on CRNTalk.com.
Hey, Lorraine, do you realize that your mother, my mother-in-law, Chef Maria, has been serving Las Vegas since 1949?
Yes, I do, Dennis. That's when she first met Howard Hughes, who fell in love with her cooking.
And in 1955, she opened her first restaurant on Fremont Street.
Yes, dear. And another great customer was Liberace.
Wow. Then in 1962, while Frank Sinatra and the Rat Pack were causing global excitement on the Las Vegas Strip, your family opened their second restaurant.
And in 1972, Elvis Presley began electrifying Las Vegas audiences and eating in our restaurant.
You know, Lorraine, this is quite a town. There's only one Las Vegas.
And there's only one Bootlegger Italian Bistro.
Folks, when you're in Las Vegas, come visit us. We'll make you feel like you're part of our family.
The Bootlegger Italian Bistro, conveniently located at 7700 Las Vegas Boulevard, South Strip. Visit our website at www.bootleggerlasvegas.com.
The smartest way for you to get the lowest prices on your plane tickets, domestic or international, is to call SmartFares first or last, but you've got to call us before you book your plane tickets. Fly anywhere in the world, fly anywhere in the U.S., and SmartFares can save you up to 75% on your plane tickets. We have the lowest airline ticket prices on over 500 airlines, and you've got a great 12-hour free cancellation window. Plus, with our live agent help, you can always get fast help and fast answers. So on your next trip, maybe today, maybe tomorrow, how about right now? Pick up your phone and call SmartFares, plus save up to 75% on your plane reservation. So call right now. 800-915-2644, 800-915-2644, 800-915-2644, 800-915-2644.
Do you owe back taxes to the IRS? Newsflash, the president has changed the tax laws, and now you may be able to pay the IRS less. If you owe $10,000 or more in back taxes, the tax doctor can help you pay the IRS as little as possible allowed by law. There are new tax laws for business owners, the self-employed, even W-2 workers. If you have a back tax problem or a few years of unfilled returns, new help to save you money is now here. Call right now to see how the new tax laws can help you. Plus, right now, we'll waive the consultation fee and give you a free tax savings report. Attention business owners, the self-employed, and W-2 workers. Make this free call to the tax doctor now and learn how to take advantage of the new tax laws that may help you pay the IRS less.
800-985-1610. 800-985-1610. 800-985-1610. That's 800-985-1610.
And we are back in the Legal Lounge with Richard Nixon. Richard Nixon Live, CRN Digital Talk Radio, streaming live coast to coast and around the world on crntalk.com. I'm joined by a noted attorney and author, Richard Nixon, author of America, An Illusion of Freedom. If you enjoy the show, you'll love his book, available on Amazon.com, BarnesandNoble.com, and as well on iTunes. And just briefly, I want to kind of get up in the altitude about this New York Times versus Sullivan case and how it's affected our public discourse. It codified the fact that any public official or figure, which is easily interpretable, is not really has no recourse really to address any defamatory statements against them unless they can prove malice from the defamer themselves, which is impossible.
Yes, absolutely. And of course, this is just fodder for the lawyers because, let's face it, that's the name of the game for lawyers, is to skew everything they can properly in favor of their clients. That's why they're called mouthpieces, because they try to make the jury or the fact finder look at it through the eyes of the client.
And what's interesting too is, and of course, to tie this back into the one of the major themes of this show, the way that the Supreme Court read the law and interpreted this case is they used the 14th Amendment Due Process Clause to apply the First Amendment, the Bill of Rights to the states, which is not something that you agree with.
And again, I know we're getting just a little bit in the weeds, but this is why we're trying to, at least I'm trying to repeat these concepts through a number of our shows so that eventually it'll become, common to talk about the 14th Amendment Due Process Clause and how it was used to apply the Bill of Rights to the states. Now, I know if you hear that for the first time, it's a mouthful, but we'll keep repeating this concept, and this is how the Supreme Court was able to render at least these three decisions, where they micromanage the states' laws, and even the state constitutional provisions, and find them unconstitutional. Again, doing what the founders would never anticipate they would have done, and that is applying the Bill of Rights to the states.
And we are only one of the only advanced democracies in the world that really has this kind of test for malicious libel in the UK and the EU. They are very, very more strict and stringent on libel and what constitutes libel. And this makes me think, Richard, about our political discourse, over these past couple of years. I can go on Twitter right now or on Facebook and call the President of the United States or the Speaker of the House or the Senate Majority Leader or the Senate Minority Leader, any name under the sun.
Yes.
And that's protected speech because they are public figures. But does that help our discourse? Does that help the marketplace of ideas in this country?
Well, I don't think it does. But again, someone said some time ago, in fact, this was someone from the ACLU, who said that the reason we are so open to almost all ideas is because we think there might be a Shakespeare in our midst somewhere. And therefore, because of that, we put up with a lot of, I'd call maybe trash. But because Shakespeare might be there just around the corner, we are going to tolerate all kinds of offensive language. But again, let me say this too, that the Constitution was never intended, number one, to solve our everyday problems. It was intended to be done by the states and their local people. And it was also never intended to frustrate people from solving their problems. And you see, that's what you have here. When the Supreme Court says it's okay for one guy to say something false about another, unless he can prove that the person knew it was false when he said it, you're basically sanctioning the media to say false things and take the chance that they'll never prove that they knew it was false. So it rewards the wrong side. Let's put it that way.
Well said. And speaking of budding Shakespeare in our midst, that leads us to our next case. Very well done. I'm just going to give a brief background of this before we head to the hard national break, and we're going to get more into it after the break. And this case comes from our home state of California, beautiful California. 1971, Cohen versus California. This is a Supreme Court case dealing with freedom of speech like we talked about. The court overturned a man's conviction for his crime of disturbing the peace for wearing a jacket in the public corridors of a courthouse that displayed the phrase, expletive deleted, the draft. This word starts with an F, and I think that we need not discuss it more. But this gentleman, like I said, he wore a jacket to a California courthouse, the Los Angeles courthouse, saying, expletive deleted the draft. I know something that you don't recommend your clients would wear, something like that kind of garment to their court appearances.
Absolutely. Yes, and again, the point here was that he did have this F-bomb written on the back of his jacket. He apparently did not cause a commotion, but he could have, and therefore I think the reasoning of the court was flawed.
Yeah, we're going to get into this case right after the break, guys, so stay with us. National break back in 4 minutes. We're here with Richard Nixon and Richard Nixon live in the Legal Lounge on CRN Digital Talk Radio. Have a question, comment, or concern, or want to just call up and call us idiots, give us a call, 818-818-6401. That's 818-818-6401, or check us out on Facebook, facebook.com/CRN Talk. We'll be right back, you guys, right after the break.
Do you want to fly somewhere, anywhere in the world? Smart travelers call myflightsearch.com for the best deals on flight tickets. Going to Manila, Bangkok, London, how about Singapore? Call myflightsearch.com for the lowest flight tickets available. What about a local vacation? Let's say you want to fly to Vegas, Orlando, Miami, Los Angeles, or Denver. Pick up the phone and call myflightsearch.com right now. We have exclusive deals that you can't find anywhere else. The only way you can get these low airline prices is by calling us. We have so many low prices available, we can't possibly tell them to you right here and now. If you're flying somewhere anytime in the next 6 months and you want the lowest airline ticket prices anywhere, you owe it to yourself to save a ton of money. So pick up your cell phone and call Call myflightsearch.com right now.
Call 800-445-3166. 800-445-3166. That's 800-445-3166. Call now. 800-445-3166.
This is today's entertainment answer. Did you know that Amazon Prime is not just for free shipping? I forget they have great movies too. This week, the Amazon Prime original video Jack Ryan, starring John Krasinski, releases. Marine-turned-rookie CIA analyst Jack Ryan becomes an unexpected hero as he races to stop the extremist from unleashing an insidious assault on U.S. soil. An action-packed thrill ride told in 8 heart-stopping episodes. Jack Ryan available this week on Amazon Prime. For this entertainment answer, I'm Matt Mungle.
When you really want Italian food, you have got to get to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. What happened to summer? You turn around and it's gone. So what do? Solution. Either stop turning around or head on over to Columbo's and enjoy the most delicious steaks imaginable. Seafood that brings awe and wonderment to your happy little taste buds. Columbo family Italian recipes so special they're kept under lock and key at an undisclosed and secure location. Jazz every night and the world's greatest meatballs. Need I say more? Oh, but I will. Enjoy the summer and head on over to Columbo's Italian Steakhouse. Good Time Central. Columbo's, because it really is that little neighborhood place you wish was down the street from you. Columbo's. Mangia.
You check things all the time, like your email every 10 seconds, or your ex's Instagram. But what about checking something as important as your credit? Well, Discover makes it quick, easy, and best of all, free. Discover is now offering FICO credit scores to everyone for free, even if you're not a customer. And checking your score won't hurt your credit. We call it the Discover Credit Scorecard. And once you know your score, you should check to see if your current credit card is the best fit for you. Check your credit, compare your card. Go to discover.com/credit scorecard. Limitations apply.
The following ad contains shocking material. Listener discretion is advised. Is someone in your family playing a dangerous game of Russian roulette? Over 43,000 people die a year from drug overdose. 120 people a day. 5 people every hour. 1 person every 12 minutes. 88,000 people die every year from alcohol abuse. Over 240 people a day. 10 an hour. 1 person every 6 minutes. Somebody you know may be next. Learn how to help someone you love get away from the drugs, alcohol, and bad influences. With the FMLA, people can take a leave of absence from their job and still keep it.
Call Quit Drugs 321 now at 800-378-3315, 800-378-3315, 800-378-3315. That's 800-378-3315.
And we are back. Richard Nixon live in the Legal Lounge here on CRN Digital Talk Radio, streaming live, crntalk.com. Check us out on Facebook at facebook.com/CRN Talk. During the break, Richard and I are solving all the world's problems, but back to the issue at hand. We were talking about the First Amendment, specifically this second case of ours on the agenda, Cohen versus California. Like I said, this young man, Paul Robert Cohen, was arrested for wearing a jacket bearing the words, "The Draft," inside the Los Angeles courthouse in the corridor outside of Division 20. And he was arrested and eventually convicted of disturbing the peace. And the section is disturbing the peace is a maliciously or willfully disturbing the peace or quiet of any neighborhood or person by offensive conduct. And shortly afterwards, this case matriculated itself up to the Supreme Court, and the Supreme Court ruled that this conviction will be overturned by 5-4. And what was the rationale of the court on this one, Richard?
Well, again, we're talking about freedom of speech and the fact that unless the government can show a more particularized reason for making a simple public display of this single 4-letter expletive a criminal offense, it had to go, I should say, Mr. Cohen had to go free. What I find interesting, though, is that again, the statute basically says Well, actually, the court goes on to say, and by the way, there was no disturbance of the peace, which suggests that had there been, had some guy gone up to him and grabbed them by the neck and said, look, I lost a father in the war, and you're against the draft, I'm going to punch you out.
Yeah.
Now, that suggests maybe that if that had taken place, that conviction could have stood. Now, I don't know why the court would make such an open-ended decision other than to say that if you try it again, maybe if the guy gets punched out, then maybe it's he can be punished.
Yeah.
I don't know.
I mean, like you said, I mean, if a riot broke out, maybe I can understand that, because that would apply to the restrictions on speech. You can kind of conflate that with, shouting fire in a crowded theater, but this did not happen. And this is interesting, Justice Harlan, he cited Justice Brandeis's opinion in a different case regarding this particular case, emphasized that the First Amendment operates to protect the inviolability of the marketplace of ideas. There's that term again, marketplace of ideas.
Yes.
But then also there's a dissenting opinion that this is vulgarity. I mean, this isn't really adding to the public discourse, really. I mean, wouldn't you say?
Well, that's right. And again, what the dissent said, that this absurd and immature antic, in my view, was mainly conduct and little speech. And you see that there again, we're getting away from the actual text of the Constitution, which was intended to protect speech. That's true. This is conduct. He didn't say a word, apparently, so where's the speech? And so, again, I fault this just for one more reason, and that is this is clearly not even speech as opposed to what was protected or what is protected by the First Amendment.
Not only did black men categorize this as conduct but not speech, which is, and we could debate that point as well, but I think more importantly to our, your philosophy and what your book covers as well, and the overall philosophy of this show is that black men didn't even think that this case should have made it to the Supreme Court.
No, that's right. And again, some of his reasoning was just the same, that, again, as Justice Frankfurter has said on many occasions, how is it that you feel that you have some authority to micromanage or delve into these state constitution or provisions? The states were intended to solve their own problems, and that's what the 10th Amendment says, that if the Constitution did not grant all these powers, if it did not grant a power to the federal government, that power remained in the states.
And just a note to our listeners out here. I mean, I asked Richard this during the break. If you're going to court, don't wear something that says F anything. I mean, that's not
right.
That's not really going to help your case out. And this is an interesting case. I mean, of course, this was 1971, the backdrop of the Vietnam War, a very, very divisive issue, the draft itself. And I believe this is right around the time where Nixon actually halted the draft. President Nixon, not
yes,
Nixon,
thank you.
Standing across from me. So it might have been a moot point by that already. And like I said, Blackman's dissent was very, very interesting. And this is going to lead us to our next, our third and final case of the hour regarding the First Amendment, free speech, and issues therefore. This is a very, very seminal case. Or actually, I remember, this is one of my very first memories of a Supreme Court case. This is Texas versus Johnson. Can you give us some background on that case, Richard?
Yes, that's very simply that Johnson, who had been or was a member of the Revolutionary Communist Youth Brigade, participated in some public disturbance or demonstrations, I should say. They threw property, broke windows, and stole different things, various items. And at one point, the demonstrator handed Johnson an American flag, which had been stolen from a flagpole outside of the targeted buildings, and they lit it on fire. And there was some speech associated with its being burned. He was convicted, but the Supreme Court found reason to overturn that conviction, saying that the government cannot mandate by fiat a feeling of unity in its citizens. And of course, I take umbrage with that.
Well, let me back up a minute. I mean, he was involved in almost riotous behavior, by throwing soiled diapers, beer cans, and various other items. This happened during the 1984 Republican National Convention in Dallas, as Ronald Reagan was nominated for his second term. But he stole an American flag. How come this is a speech issue, not a criminal law issue?
Well, again, I'm sure that the attorneys didn't brief this case properly, or it should have been one involving, frankly, the stealing of the flag as well.
We're going to talk more about this, you guys, after the break. We're headed towards one of our last breaks of the hour. But this is a very, very interesting case, and I think it should be noted that this is one of the most significant divisive issues in this country. Every year, a resolution is put before the House of Representatives calling for a constitutional amendment to stop the desecration of the American flag, and every time it fails in the Senate. But there's some interesting opinions here from the Supreme Court justices about this case. From some justices that I think will have opinions that our listeners might not think they would have, specifically one recently deceased, Antonin Scalia. And so we're going to talk about this case right after the break, you guys. And like I said, I teased at the top of the hour. In our last segment, we're going to play some sound from this morning's Mr. Kavanaugh's confirmation hearing, so I think is going to be very, very representative of the overall theme of this show. So make sure to stick around for that. I'm with Richard Nixon. He's a practicing attorney. He's an author. Check out his book, America, An Illusion of Freedom, available on Amazon.com, Barnes & Noble, as well as iTunes. And like I said before, if you guys personally knew Richard during his time of service, and thank you for your service, sir, 1963 to 65, or when he was in country in Vietnam in 68, if you personally knew Richard, give us a call, 818-818-6400, and we'd like to give you a free copy of his fantastic book. Stay with us, you guys. We'll be back in 2 minutes.
Have you purchased a wine refrigerator or put a wine cellar in your home? Maybe you have a new wine rack. Great news, but what wines will you buy to stock your wine rack? Let me, Michael Horn, help. I'll find the wines for your wine cellar with your taste in mind. We'll determine what varietals, Cabernet, Pinot, Chardonnay, what types of wine, California, French, Italian, you like. We'll find you one-of-a-kind wines from all of our friends we interview daily on the What's Cooking Show and the What's Cooking on Wine Show. On a budget, we'll find you the best affordable wines. Want hard-to-get library wines? We can source those for you, too. And if you need cigars, let L.A. Rams sports legend and iconic actor Fred Dryer make your selections. Hey, we can even host a wine dinner for you or set up a sports cigar party with Fred. Call me, Michael Horn, at the What's Cooking Today show. Call 818-818-6400. That's 818-818-6400. Let us find the dream wines of your lifetime.
If Ernest Hemingway was alive today, would he say this to you?
Shakespeare, Mark Twain, Edgar Allan Poe, all great writers. And after reading your book, I simply must add you to the list.
Wait, you don't have a book yet. So make a free call to Page Publishing. Their expert staff can help you turn your book idea into a real book, a masterpiece that could someday make the bestseller list in hard copy and digitally all across the world. Page Publishing can help you completely take your idea for a book, write it, and publish it. So if you want to join the ranks of some of the most famous authors in the world, call now for a free information kit. Turn your book idea into publishing gold. Make a free call right now to Page Publishing.
800-378-3212. 800-378-3212. 800-378-3212. That's 800-378-3212.
And we are back here in the Legal Lounge. Richard Nixon live here on CRN Digital Talk Radio, crntalk.com, streaming live coast to coast and around the world. Check us out on Facebook, facebook.com/CRN Talk. Also available on Amazon, or on the Amazon Echo. All you have to do is say, Alexa, play CRN1 on TuneIn, and we are right there for you. And so, Richard, let's get back to this third and final case we're talking about, Texas versus Johnson. A very, very divisive issue in this country. You know, the flag represents a lot of things for a lot of people. And once again, this young man, Mr. Johnson, he was burned a flag at the '84 Republican National Convention, was arrested on Texas state law.
Yes.
Because we should mention that at the time, 48 states out of the 50 in the Union had laws on the books punishing the desecration of the flag.
Absolutely. And again, I think the court is misplaced here in its analysis, because it says, recognizing that the right to differ is the centerpiece of our First Amendment freedoms, a government cannot mandate by fiat a feeling of unity in its citizens. Now, again, I don't think that's what the law was doing in Texas that said you can't burn the American flag. They're not saying, here's the American flag, adore it, you must honor it. They're simply saying you cannot destroy it because the rest of us might honor it, and it creates unity for the rest of us. So you're destroying our sense of unity with each other. If you don't want to join our unit, then you don't have to. But I think, again, the court's emphasis is misplaced. But there is a dissent that I think you want to describe.
Yeah, this is, well, there was, John Paul Stevens had a dissent, but also as well as Rehnquist had a dissent, and Rehnquist's dissent was very interesting to me. He's quoting here, the American flag throughout more than 200 years of our history has become to be the visible symbol embodying our nation. It does not represent the views of any particular political party, and it does not represent any political philosophy. The flag is not simply another idea or point of view competing for the recognition in the marketplace of ideas. Millions and millions of Americans regard it with almost mythical reverence regarding of what sort of social, political, and philosophical beliefs they might have. That's what a very, very interesting dissent, and I think that he's on the right track there.
I do too, and I don't know if you mentioned Stevens' quote from this case, but he says that the flag is much more than a proud symbol of the courage, the determination, and the gifts of nature that transformed 13 fledgling colonies into a world power. It is a symbol of freedom, of equal opportunity, of religious tolerance, and of goodwill for other peoples who share our aspirations. The value of the flag as a symbol cannot be measured. Stevens concluded, therefore, that this case has nothing to do with the disagreeable ideas. It involves disagreeable conduct that, in my opinion, diminishes the value of an important national asset, and that Johnson was punished only for the means by which he expressed his opinion, not the opinion itself. So again, he was punished for the way he expressed himself, not for what he expressed.
And I think his expression would be far more effective. And I saw this, recently watching the Ken Burns documentary on the Vietnam War.
Yes.
Is that there's nothing more patriotic than protest. I think that some people, would believe that. And to carry the flag in reference of that protest, not desecrate it, but carry it strong on your shoulders.
Absolutely. And again, there's so much today in terms of anti-establishment stuff that this just feeds into the what I call the trough, that if someone from afar, for instance in Moscow, wanted to destroy the unity of this country, what better symbol than our unity than our American flag, and to somehow sanction its destruction?
Well, let me ask you this, Richard. We're about 2 minutes before the break, and one of the signatories, one of the justices in the affirmative on this case, was a strict constructionalist known as Anthony Scalia. And you'd think that Mr. Scalia would be the last person to be a concurring opinion on that. What do you think was going through his mind?
Well, again, every now and then there are people who consider themselves purist. He was one of those that felt it was so important to be unshackled and be able to speak your mind, that he would do as the ACLU did in protecting the Nazis in their different parades and so on. No one could have disliked the Nazis more than the ACLU, but they said, okay, in this country you have the freedom to say as you please. And I think Scalia got caught up in that mood.
Yeah, it's very interesting. And so now, every year they try to introduce a constitutional amendment that would punish those who want to desecrate the American flag. And like I said before, every year that fails in the Senate. But like I said, just to tie things together, like I said before, 48 states in the Union had laws on the books. And how did the Supreme Court use their authority to, once again, by the 14th Amendment due process clause?
Yes, and as we've said before, the Constitution was never intended to solve our social problems, and nor was it intended to frustrate our people from solving their local problems. That is to say, in this case, each one of those states had a right to have that is the burning of the flag punishable by some kind of criminal offense, if they so choose. If the people of that state didn't want to do it, they didn't have to. But that should have been left up to the states.
And like I mean, and just for context too, I mean, these laws in the books, it's not like they're going to put you away for 50 years. It's usually a fine, if that. And so that, and once again, like we said before, that really erodes the community standards of that the community themselves set.
Absolutely.
So
absolutely.
Right after the break, you guys, I teased it. We're going to have a quote, some sound from a sitting United States senator that pretty much sums up the philosophy of this show and a lot of the ideas that we've been discussing over these past few months. So stick around, you guys. We'll be right back with some sound, and I think it's going to be very, very interesting, and we're going to wrap things up. So stay with us here. The Legal Lounge with Richard Nixon. Richard Nixon Live, streaming live coast to coast and around the world on CRN Digital Talk Radio. Stay with us.
Do you want to fly somewhere, anywhere in the world? Smart travelers call myflightsearch.com for the best deals on flight tickets. Going to Manila, Bangkok, London, how about Singapore? Call myflightsearch.com for the lowest flight tickets available. What about a local vacation? Let's say you want to fly to Vegas, Orlando, Miami, Los Angeles, or Denver. Pick up the phone and call myflightsearch.com right now. We have exclusive deals that you can't find anywhere else. The only way you can get these low airline prices is by calling us. We have so many low prices available, we can't possibly tell them to you right here and now. If you're flying somewhere anytime in the next 6 months and you want the lowest airline ticket prices anywhere, you owe it to yourself to save a ton of money. So pick up your cell phone and call myflightsearch.com right now.
Call 800-445-3166. 800-445-3166. That's 800-445-3166. Call now. 800-445-3166.
What are you going to do with your old car? You can try selling it, you could junk it, or you could donate it to Heritage for the Blind. Your car will be towed away for free, and your donation is tax deductible. Just call 1-800-785-9618. Heritage for the Blind accepts cars, vans, trucks, and boats. It doesn't matter if your vehicle runs or not. It will be towed away for free, and you'll be supporting those that need help. Heritage for the Blind is a nonprofit organization that helps the visually impaired live fuller lives. Call right now to donate your car, and as a special thank you for calling, you'll receive a free 3-day vacation voucher to many exciting locations. Call Heritage for the Blind right now, 1-800-785-9618. Donating is easy, and your vehicle is towed away for free. Plus, you'll get a free vacation voucher. Call now, 1-800-785-9618. That's 1-800-785-9618.
Still got those annoying critters? I'm talking bees and fleas, spiders, ants, roaches, bed bugs, and those disgusting rodents. Have you made that call to Dewey Pest Control yet? What's holding you back? Get rid of them, and I mean right now. When the heat brings them out, it's time to call Dewey, because Dewey knocks them down and keeps them out. Dewey's an 89-year Heritage California family business with 32 offices statewide. Think you got those 24/7 wood-munching termites chewing up your house? Call Dewey right now for their free inspection. And all this month, get $89 off with a regular maintenance program. Call 800-209-0900. That's 800-209-0900. Just one call to Dewey does it all. 800-209-0900. Or get your free inspection online at DeweyRadio.com. That's Dewey, D-E-W-E-Y, DeweyRadio.com.
And we are back. Richard Nixon live here on the Legal Lounge at CRN Digital Talk Radio. Thank you so much for joining us. And Richard, when you came in today, you asked me, have you been watching the Kavanaugh hearings? I said, yes, sir, I have. And you said there's some tremendous sound from a man, a sitting United States Senator from my ancestral home in Nebraska, Mr. Ben Sasse. And I'm going to just let it rip. So stand by. Here, give me cut 13.
Yes, excellent.
Just 4 brief points. Number 1. In our system, the legislative branch is supposed to be the center of our politics. Number 2, it's not. Why not? Because for the last century, and increasing by the decade right now, more and more legislative authority is delegated to the executive branch every year. Both parties do it. The legislature is impotent, the legislature is weak, and most people here want their jobs more than they really want to do legislative work, and so they punt most of the work to the next branch. Third consequence is that this transfer of power means the people yearn for a place where politics can actually be done. And when we don't do a lot of big, actual political debating here, we transfer it to the Supreme Court. And that's why the Supreme Court is increasingly a substitute political battleground in America. It is not healthy, but it is what happens, and it's something that our founders wouldn't be able to make any sense of. And fourth and finally, we badly need to restore the proper duties and the balance of power from our constitutional system.
So there you have it, folks. And I think one thing that really struck out to me, you know, that it's almost like he's been listening to our show, because we've been talking
absolutely.
We've been talking about that in a substitute political battleground, as what he called the Supreme Court. It's fascinating.
That is excellent, excellent. And again, to just summarize it here real quick, Article 1 says that all legislative powers herein granted shall be vested in a Congress. Yet these three cases and others show that in substitution for the legislature passing the laws or writing the laws, our own Supreme Court did it. They literally wrote the law for these three cases that we discussed today. And so they're not only in violation of Article 1, Section 1, but they're also in violation of the First Amendment, which says Congress shall make no laws. Well, technically they're not in violation since they're not Congress. But my point is they found another way around the prohibition against Congress. And by going to the 14th Amendment due process clause, they were able to micromanage what the states did and find the state laws unconstitutional.
Yeah, we have three cases we discussed over the hour: New York Times versus Sullivan, and Cohen versus California, and Texas versus Johnson, all in jurisdictions just as diverse as this country as a whole. But yet the Supreme Court wanted to levy a nationwide, a federal standard on these three cases in these three different municipalities, and that just seems to go against the the kind of community standards.
Excellent point, Mike. That's exactly the point. That what they do, they rendered things homogeneous, and that was not intended. Justice Brandeis, I was not necessarily a fan of his, but he described the states as laboratories to solve social problems. And as one state solves a social problem, the other states learn from it and can emulate or modify. That they were intended to be laboratories for our social an economic program.
Yeah, I mean, the homogeneity, taking the homogeny out of the states, out of this nation as a whole, and that's, we can debate that here and there, but that's a valid point of view on both sides. But I think you guys know where we stand on these issues. But this has been a great hour. I enjoyed it. I enjoyed it thoroughly. These three cases are fascinating cases, and that piece of sound from Senator Sass was very, very insightful and very representative of the show overall. You guys, thank you so much for joining us here in the Legal Lounge with Richard Nixon. You want to drop us a note, just go to richardnixon@crntalk.com, or drop us a note on Facebook, facebook.com/crntalk. We'll be back next week more with legal issues and whatnot. Richard, thank you so much.
And let me hear from the vets.
Absolutely, guys. Any vets that served with Richard, know him personally, give us a call, 818-818-6400. That's 818-818-6400. We'll be back next week. More in the Legal Lounge with Richard Nixon. I'm Mike Gary for CRN Digital Talk Radio. We appreciate it. We'll be back next week. Thank you so much for joining us. Take care.